Recently, I've been studying the plight of indigenous people in Latin America, indigenous communities, uh, which is a group that has been historically excluded and greatly disadvantaged, both economically, politically, and of course legally. Um, and in recent years, there's been some major political changes which have which give cause for some optimism. And I've been very keen to sort of identify whether that optimism is justified. Basically, these are people who often live in remote parts of the countries, in the countryside, who live in hamlets or villages that don't have basic social services or any services in general. And the exclusion from a legal point of view is the fact that they don't have access to legal institutions, both in terms of just simply petitioning authorities, of political authorities, but also if they have a dispute among themselves, or especially with people who are not members of the community, they have to resort to the courts. And the courts are far away in terms of distance, and they're also far away culturally, because they often, or not often, generally, the courts function in Spanish, and these people very often do not speak the language. Or if they speak the language, they do not have the language skills to be able to respond to to make a claim or to respond to allegations of criminal allegations. There's also a question of resources, because using the courts is very expensive. Well, I think that first of all, the approach of the World Justice Project is very commendable. I think the notion that one should take a multidisciplinary approach to these problems is very important, and it's an approach which has not been taken by any other organization active in the field. Most organizations have been very legalistic, assuming that once you address the legal issue, you resolve the social question. And very often you need to address the social question to be able to understand why is it that the legal issue is so difficult to resolve. So from that point of view, I think that a multidisciplinary approach, and an approach which seeks to understand the realities of the context, which are always much more complicated than when one reads about in a book about, you know, Mexico or Guatemala or whatever, and that is a way of both making a contribution to communities that are excluded, understanding how they resolve their own disputes and conflicts, but at the same time learning lessons that the official system has to learn. Some of those lessons the official system will never absorb probably. Sometimes, you know, the problem of corruption will not be resolved, or at least the problem of corruption has to be resolved by political means, by opening up the system, by exposing the people and so forth. So the two things go together, and they're all involved in building the rule of law rather than creating the rule of law, and it's a slow process. The most important change in the Latin American context is the fact that indigenous communities have a sense of their own self-respect and their own capacity to exercise and to claim rights, something that they didn't have in the recent past. Now they are recognized as having an identity which is different, but at the same time they're part of the country. And of course the difficulty then is how to accept some of the consequences of that recognition. One of the main consequences is that their uses and practices, or customary law, is recognized by many constitutions in Latin America, which is an unusual development. It's a development that is so unusual that I don't think that many Latin American lawyers have actually had time to digest, in the sense of, you know, what are the implications. So there is an introduction of legal pluralism in Latin America, which I think is actually very, very positive.